Dang it, I almost forgot to put myself back on here. Hey guys, welcome. It's a second video today, but I wanted to get this to you because this is hot off the presses today, ladies and gentlemen. Today, the Northern District of Texas, Fort Worth Division came out with an order that affects not a lot of people, but it affects enough people. But regardless, it's about the ATF's unconstitutional power grab. You may recall I did a video about the forced reset trigger letter that the ATF sent out to FFLs. Well, Judge Reed O'Connor, the United States District Judge for the Northern District, the Texas Northern District Court, has just issued an order. And I've glanced over this. I've read through it. I want to go through it with all of you. This is the opinion and order on plaintiff's motion for a temporary restraining order before the court. Our plaintiff's motion, and plaintiff, of course, we got the National Association for Gun Rights. If you are not a member, ladies and gentlemen, you need to join National Association for Gun Rights. Why? Especially if you have a forced reset trigger. You need to be a member of the National Association for Gun Rights. Hey, James, how you doing? Tristan, our guy. Because this applies to you. And if you've got a forced reset trigger, this is important. So, opinion and order on plaintiff's motion for temporary restraining order before the court, or plaintiff's motion for a TRO, the brief in support, the appendix, blah, blah, all this other stuff. Having considered the parties' briefing and applicable law, the court grants plaintiff's motion for a TRO, a temporary restraining order. So the judge is saying, National Association for Gun Rights, you win, in order to preserve the status quo until either September 27th or such time that the court rules on plaintiff's motion for a preliminary injunction, whichever is earlier. Therefore, the court orders that defendants, along with their officers, agents, servants, and employees, who are the defendants, the Department of Justice, which includes the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and they are enjoined. In other words, you are bound to this order. Okay, defendants, Garland and his people, are enjoined from implementing or enforcing in any civil or criminal matter against plaintiffs Patrick Carey, Travis Spiegel, and James Wheeler the ATF's challenged definition of machine gun. All right. So here's a little bit of background here. The United States Congress delegated to the ATF the authority to regulate firearms and interstate commerce under the GCA of 1986. In a 2018 regulation, the ATF expanded the definition of machine gun. You notice this? The ATF expanded the definition of machine gun. Congress delegated to them the authority to regulate firearms, but not to change definitions. A few years later, the ATF determined that, and a few years later means last year, the ATF determined that additional types of firearms qualify as machine guns and are thus illegal to possess or transfer. One of those prohibited firearms is a forced reset trigger, of course, according to the ATF. Plaintiffs brought this suit under the Administrative Procedure Act to challenge the legality of the ATF's broad definition. The Administrative Procedure Act is how government entities are required to process rules that are going to require citizens to abide by. So, for example, you might remember when the ATF passed its unconstitutional rule on the pistol brace. Well, you could say that the way they did that, they did it right because they went through the APA, and the APA explains exactly how rules are supposed to be brought up. You know, they're supposed to be recommended. They're supposed to add a public comment period. Then you've got another period of time. There's a whole bunch of stuff to the the APA. All right. However, with the forced reset trigger issue, they didn't even bother to create an unconstitutional rule. What the ATF did was it just sent out a letter and says, we hereby decree that the forced reset trigger is hereby and forevermore considered a machine gun. So says we, the unconstitutional agency dubbed by His Royal Majesty, the ATF. that violates the APA. A letter is not law. A letter to FFLs is not law. And rules, in some cases, are not law either. That's a whole other video about how rules and stuff can be treated as law, but in order to be treated as law, they have to abide by the APA. They just have to. This was one of my favorite classes. Most people find administrative law incredibly boring. I loved it. And as a matter of fact, I did my APA paper on the ATF when I was in law school. Okay, enough of me. A forced reset trigger is a semi-automatic assembly that allows the trigger to reset quicker than it otherwise would using a traditional trigger return spring. This assembly enables the user to fire a firearm at a quicker rate than a traditional trigger. If you remember in my video that I wrote about the ATF's unconstitutional FRT issue, you remember that I went over the federal definition of what makes something a machine gun, and it's when it fires more than one round with a single action of the trigger. Nowhere in federal law does it state that something can be designated a machine gun just because it increases the rate of fire. As long as it's one bullet per one trigger squeeze, you're fine. So reviewing the basic mechanism of firearm is necessary. So it goes into exactly how a forced reset trigger works. I'm going to read this paragraph, but I'm going to skip down to the more important areas because a lot of this just becomes very mundane and boring. But this really confirms what I said in my video as well. Reviewing the basic mechanism of a firearm is necessary to understand how an FRT works. The function of any trigger is to release the hammer. This occurs when the trigger is pulled back to the point that a trigger sear releases the hammer from its retained position. Once released by the trigger, the hammer pivots to contact the firing pin. Once contacted, the firing pin then strikes a chambered ammunition cartridge or round. And then that, of course, which causes the gunpowder in the cartridge to combust. The combustion effect propels the cartridge's bullet out of the barrel of the firearm. Once fired, a standard semi-automatic trigger returns to its reset state, its ready to fire or set position, by allowing the firearm to function once again by starting the mechanism all over again. In other words, the firearm only fires again by the user pulling the trigger to release the hammer. An FRT that forcibly returns the trigger to its reset state. FRTs are designed to achieve this by the hammer resetting the trigger when the bolt carrier cycles to the rear. A locking bar mechanism or mechanically locks the trigger in its reset state, preventing the user from moving the trigger rearward to function by releasing the hammer until the bolt has returned to the inside battery position. In other words, you've now got a mechanical thing doing exactly what your finger does. Okay, when firing multiple shots using an FRT, the trigger must still reset after each round. One action of the trigger per round. The trigger must reset after each round is fired and must separately function to release the hammer by moving far enough to the rear in order to fire the next round. So it still is not an automatic weapon, but the ATF says it is. Now, here's all of the statutory background here. I love that Cargill v. Garland is mentioned in here as a source. It goes through the law of what a machine gun is and all that kind of stuff. Who are the parties? Of course, the parties are NAGR members and Texas gun rights members, as well as thousands of members in the Northern District of Texas who are the institutional plaintiffs. That's you. So this, he owns some force reset triggers. He received this letter, blah, blah, blah. So it goes through standing. Yes, they had standing. Some of the pre-enforcement challenges. The defendants call into question the veracity of pre-enforcement judicial review of laws carrying criminal penalties. According to the defendants, such review encroaches on the prosecutorial discretion that properly rests with the executive branch. Yeah, but you can't prosecute a crime that doesn't exist. You can't prosecute a crime made up out of thin air. Defendants contend that granting a TRO and joining civil and criminal prosecution violates constitutional separation of powers principles. Blah, blah, blah. You can't do this. We're the Biden administration, and therefore, this is wrong, and you can't enjoin us. Well, the court says yes, they can, and it goes through this whole analysis. You can read this on your own. This talks about the legal basis for injunctive relief. Injunctive relief is guaranteed when there's a likelihood. One, you've got to be able to succeed on the merits. Two, there's got to be irreparable harm, and then you've got to balance individual and state interests or party interests. So here it is right here. A likelihood to succeed, a substantial threat of irreparable harm, and that the balance of hardships weighs in its favor, the favor of having an injunction, and that it will not disserve the public interest. So I kind of melded those two together. The last two factors merge. Oh, just there you go. The last two factors merge when the government is the opposing party. So that's kind of what I just did without having to read it. It talks about, yes, they're likely to they're likely to win on the merits because the law is the law and it's not a machine gun based on how it's read. So it goes through that as well. Talks about the substantial threat of irreparable harm. Yes, because you're not going to be able to recover at the end of litigation the damages of loss of freedom. You can never get your freedom back. So goes to that, and then the credible threat of prosecution is what they're using there. Let's see, we got the compliance costs, balance of hardships and the public interest. So these are all, like I said, just thing here. So here we go down to the end. In some, plaintiffs have successfully demonstrated to the court that they are entitled to a temporary restraining order. Having considered the arguments, evidence, the law, the court holds that the relevant factors weigh in favor of granting the temporary restraining order. Accordingly, the court temporarily enjoins defendants from initiating any actions against against these plaintiffs, which is also the National Association for Gun Rights and its members. Further, the court temporarily enjoins defendants from requesting that plaintiffs surrender voluntarily or involuntarily any FRTs in their possession. So they can't go after these guys whatsoever. All right. Here's the scope of the restraining order. Again, it gives they give the parties a little bit of extra time, 14 days before they're going to rule on the actual injunction itself. So this is a temporary restraining order. They've got 14 days to come before and show good cause if they want to extend that. And then it would just become, as long as the plaintiffs are going to request that the TRO remain in place until such time that the court can rule on the injunction motion. So this is just saying, okay, we think that based on what's been presented by both parties, yes, they can win. And while we're litigating this, we are going to do a temporary restraining order against enforcing this issue. So this is a request. The court construes this as a request for an extension and finds good cause to extend the TRO for another 14 days because otherwise it would expire prior to when this motion for a preliminary injunction is due. So there you go, folks. Parties have agreed. Because the parties agreed, schedule for the preliminary injunction briefing comes ripe on September 19th, 2023. The court will extend it for an additional 14-day period. The TRO will expire 28 days from the date of this order on September 27th, or on the date the court issues its ruling on the forthcoming preliminary injunction, whichever is earlier. And so for that reason, ATF, you may not enforce your unconstitutional letter that says that the forced reset trigger is a machine gun, because the ATF's expanded definition of machine gun has been determined as likely unlawful because it violates the APA and it violates the Constitution, and FU to the ATF. All right, guys, this is so ordered on this day. If you would like to look this up, if you have a Pacer account, here is the case number again, 4:23CV00830. This was just filed today, just filed this afternoon, fresh off the presses. The forced reset trigger rule. It's not even a rule. It's a letter. It's a letter that the ATF put out. If you want to know more about that, check out my videos. Go watch my video on why the ATF's letter should have always been ignored and why it was unconstitutional. And with that, thank you all for being here. Thank you for listening. Thank you for watching. Please like and share this video. Let everybody know, first of all, to join the National Association for Gun Rights. They are kicking ass and fighting for you. As a matter of fact, I am a life member, and I I've actually going to be working with them on some cases coming up. So keep your eyes open for that. And with that, I'm going to let you guys go. Be safe, be free. Take care.